Good morning, students. Our today's topic in the subject of Business Studies O Levels is employment and laws. So, where employment is, laws are there, and laws have to be abided by, which are passed by the government or through the company itself. So, concentrate yourself. A lot of ideas and concepts are going to be involved. So, we are going to start now making decisions. There are a number of the laws which relate to the employing workers. Some affect how a business recruits workers. Other protect workers when they are employed. So before the employing of the workers, laws apply, and after getting the employment, there are also laws which have to be fulfilled. Businesses must have policies and procedures to make sure they stay within the law. And I'm going to explain this topic through a story that will be more interesting and easy for you to understand this topic. So here the story begins. Navdeep Ghosal is employed by Matthew Walter, a small business offering a skip service to local businesses and individuals in Ipswich. She was appointed as an administrative assistant and does most of the clerical work in the company. This includes answering telephone calls and acting as a receptionist for clients who call into the office. The law. Businesses have to obey the law. If they fail to obey, they risk two things. So, number one, they can be prosecuted by a number of the government departments and agencies, such as the health and safety inspectors, and possibly fined. So this is the one risk of not fulfilling the laws. The second risk, they can be sued by people or other businesses which have lost out as a result of their actions. Damages might then have to be paid. So these are the two reasons due to which the businesses have to fulfill the laws. Getting a job. Navdeep was one of the 10 applicants for the job. In law, applicants for a job have certain rights. Number one, these rights try to give all applicants equal opportunities when seeking work. Number two, in particular, employers are not allowed to discriminate because of the gender or racial origin. Matthew Walter, for instance, could not have advertised for a female secretary. Equally, it could not have advertised for the secretary of the European origin. So, the employer cannot discriminate on the basis of the gender or the racial origin. Disabled applicants must be given the job when they are clearly the best applicant. The only exception to this is if there are substantial reasons for not doing so. These reasons might include having to make hugely costly alterations to the buildings so that one disabled person can do a job there. So this is the reason due to which you can refuse or you cannot offer job to a disabled person. The next, employers, however, must be prepared to make reasonable adjustments for disabled staff. So if the adjustments are few and minor, so these adjustments should have to be done. Okay, the next thing that we are going to read is the starting work. Navdeep signed a contract of the employment with Matthew Walter before she started work. This is an agreement between the employer and the employee. It includes conditions such as rates of pay, hours of the work, holidays, pension contributions, and the amount of the notice that must be given if the worker wants to leave or the employer wants to make the worker redundant, for example. So these are the things which should be included in the contract of the employment. Under the Equal Pay Act 1970, Navdeep must be paid the same rate of the pay as the male doing the same job, a similar job or a job with the equal demands. So there should not be discrimination between the local or the foreigner, between the racial origin, and between the gender. Next thing that we are going to read is the protection at work. Matthew Wetters, like any business, needs to conform to the Health and Safety at Work Act. The premises are regularly visited by the inspectors from the Health and Safety Executive to ensure the required standards. For instance, drivers at Matthew Wetters take skips to and from sites. They have to be able to operate the lifting equipment on their lorries safely without endangering themselves or the people on the site. Matthew Wetters must also ensure the health and safety of the Navdeep. This could include providing a suitable chair and giving her regular breaks. So these are the safety measures or the benefits which should be given to the workers. Matthew Wetters must also be aware of the equal opportunities. If Navdeep applied for more senior post in the company, the law says that she must have the same chance as any other employee. It must be illegal for Matthew Wetters to discriminate against her because she was a woman, disabled, or from an ethnic minority. Some of the drivers belong to the trade union. Navdeep is not in a union. The law says that any worker has a right to join or not to join a trade union. So it is the right of the worker. Either he wants to join or not join. A business does not have to recognize or negotiate with the trade union. It can choose to deal with the workers individually rather than trade union representatives. However, it cannot prevent workers taking industrial action such as striking. Leaving work. The law affects workers when they leave their job. Finding a new job. Workers who have found new jobs have to resign from their post. They then have to work out their notice. Their contract of employment will state how much notice a worker needs to give his or her employers when leaving. In Navdeep's case, her contract says that she must give a month's notice before leaving. So this is the condition which is included in the contract of the employment. Both employers and the employee have the condition if they want to leave the work or if they redundant a worker. So a notice should be given and a prescribed time should be given to the opposite party. Next thing that we are going to read is retirement. Most workers pay into pension schemes so that they can receive a pension when they retire. The law does not force a business to have its own scheme, but Matthew Wetters does have one. Both Navdeep and Matthew Wetters pay regular amounts into a scheme with the Standard Life Insurance Company. Redundancy. In law, a business can make workers redundant if their job no longer exists. Nearly all the workers made redundant became entitled to redundancy payments. If the company makes any worker redundant in future, they will be entitled to the redundancy payments if they had worked for the business continuously for more than 2 years. So this is the condition. If the worker has worked for the company for more than 2 years and if he has made redundant by the company, so he will be entitled to get the redundancy amount. The next thing that we are going to read is the dismissal. In law, workers can be dismissed, that is sacked, if they are either unable to do the job or there is misconduct involved. In less serious cases, the worker is first given a verbal warning, then a written warning if no improvement in this situation, and then finally sacked. In more serious cases, a worker can be sacked immediately in the cases of the gross misconduct, such as failure to observe safety regulations. So if he is endangering his own life or the lives of the others, he may be immediately sacked if he is committed of the crime of the theft or fighting. So these are some serious issues on the basis of which he or she can be immediately sacked. Workers can take case to the industrial tribunal on the grounds of the unfair dismissal. An industrial tribunal is a court of the law which deals with issues such as unfair dismissal, discrimination at the work, and sexual harassment. Unlike in most courts, lawyers do not have to be used. People can argue their own case in front of the tribunal. The tribunal is also informal, with members listening to the presentations and asking questions to find out the truth about what happened. The idea is that the law is then accessible to every worker. The tribunal has the power to fine a business if it is breaking the law and can pay damages to the workers. And finally, we are going to read some key terms in the lecture. The first one is the contract of the employment, an agreement between the employer and the employee about the conditions under which the employee will work, including rates of the pay and holidays entitlements. The next thing that we are going to read is the discrimination, favoring one person rather than another. In the UK, it is illegal to discriminate in most jobs on grounds of the gender or race. The next term is equal opportunities, where everyone has the same chance. The next key term is industrial tribunal, code which deals with the law relating to the employment. And finally, students, I have made some questions from the lecture. So solve it with the help of the lecture. These questions will help you a lot in attempting the paper more conveniently. So this was the lecture, students. I hope so this will be much more interesting and easy for you to understand. So read this lecture again, understand it, learn it, and make your notes. Thank you so much.